Alright, so welcome to my YouTube channel. So we'll continue from where we stopped. Sorry, I've been away for some time. I've been doing a lot of litigation and it has not been easy. You would want to be lawyers. It's not easy, but it's doable. Yeah. And then when you put in the work, you see your results. Okay, so now let us continue with terms of a contract. Of course, we've looked at the difference between a term and the mere representation. If you have not watched it, if this is the first video you're watching, please stop it. This video is part of a playlist. Go and start from the first one. Now, we will look at terms of a contract based on its degree of importance. Now, what do I mean? We will start from the least important down to the major or patapata of them all. Now, the way I listed them here, of course, is how it is based on the degrees of importance. But how I will be explaining it is that I will explain conditions and warranties together. Why? Because they are commonly used and they are commonly misunderstood. So after I'm done explaining conditions and warranties, I will now go into innominate and intermediate terms. Innominate or intermediate terms. Now, from the word intermediate is it's neither big or it's neither small. Intermediate is neither long or it's neither short. Intermediate is neither warranties nor is it conditions. It is in the middle. And so your ability to know when is it an innominate or intermediate term, when is it a condition, and when is it a warranty, then when is it a fundamental? Of course, fundamental term is very simple because that is the patapata of them all. But the ones that you might have a little bit of confusion is conditions, warranties, and innominate terms, especially innominate terms. I will tell you the truth. Until I left 200 level in my law faculty when I was a law student, I never understood intermediate terms and innominate terms. Why? Because it was looking like warranties and it was also looking like conditions. So if you don't take time, you might end up like me and leave 200 level, and I had to understand it later when I was now doing a case on breach of contract as a lawyer. All right, so let us start. What are warranties and conditions? Now, conditions, first of all, we'll start with conditions. Now, conditions should be, first of all, the way we use conditions, especially as it concerns contract, is in so many ways. But the main three ways is condition precedent, condition subsequent, and condition inherent. Now, of course, we'll be concerning ourselves with condition inherent. That is condition inherent in the contract. The condition that makes up the contract. That is what we will concern ourselves with. But before we talk about the one that we will concern ourselves with, let us first explain this one that I've mentioned. What is condition precedent? Now you want to perform a contract or you want to enter into a contract, but that contract cannot be entered into because there are some things that should be done that has not been done. You know what I'm saying? So you want to buy a particular piece of land, but the condition you have put for you to buy that piece of land is that the owner of the land clears the bushes or the owner of the land fences it. So if the owner of the land refuses to clear the bushes or the owner of the land refuses to fence it, depending on the condition you have given the owner of that land, then that particular contract cannot be said to come into fruition because there are some conditions that must be fulfilled precedent to the performance of the contract. That is condition precedent. In your legal method, you learn judicial precedent, something that has happened before. A case that you are citing, so a case that has happened before. The decision of the court in previous cases. So, condition precedent now, that thing must happen before the contract will come into existence. That is condition precedent. Now, we've seen that condition inherent, just like I've explained, is the condition that comes with the contract. Yes, if you pay me money, I will give you my phone. That is the condition that comes with the contract. There is no condition precedent or subsequent. The condition is the contract. That is condition inherent. The condition inherent in the contract. And that is the condition we have to be explaining here. That is when I write this condition here, it is condition inherent that I am talking about. Like I have already said, we will be concerning ourselves with condition inherent. But it is very good for you as a student to know the meaning of condition precedent and condition subsequent. Now, what is condition subsequent? Just like we have seen that condition precedent is a condition that must be fulfilled before a particular contract comes into fruition. Condition subsequent is that condition that must be fulfilled after a contract has come into fruition, without which that particular contract will die. There has been so many attempts to make some kind of example of condition subsequent, but condition subsequent is rare. We have not really seen, but a particular case, which if I say the fact of the case, you would have to look for the name. This person wanted to borrow money from a particular bank. The collateral he wanted to give the bank in order for the bank to take and give him the money, so that when he pays back, he will collect his collateral back. That's the landed property. The bank now hired an estate valuer to value the land and see what actually the amount is, to see if that particular land can be used to collect this huge amount of money. The estate valuer, of course, said this is how much I would collect to value the land. However, the contract did not now come into fruition. The loan agreement was not now taken. Now, the estate valuer was now saying, the money that you're supposed to give me to value the estate, or am I not going to value the estate again? The bank said there's no need for you to value the estate again. The estate valuer took the bank to court, and the court said it will be unfair if the bank is meant to pay this money, provided that a condition that would have been subsequent did not come into fruition. So that is the closest example of the condition subsequent. But like I said, we are not concerning ourselves with condition precedents and condition subsequent. We are conditioning ourselves or conditioning our mind for condition inherent. Now, that being said, conditions and warranties are usually used so commonly and so interchangeably that most of the times you might not even know the difference between the two of them. In fact, the difference between the two of them is so slim that you might be confused on when a warranty is used and when a condition is used. But the difference is based on what happens when any of them is breached. While conditions, just like it is being indicated here, because I said this particular thing is from the weakest to the strongest, while condition is actually stronger than warranties, we will also have to note that conditions are essential to a particular contract, while warranties are just collateral to it. And for you to know the difference, you have to, in fact, it is important you know the difference between conditions and warranties so that you would know what happens when any of them is breached. So from the beginning, we already know that when a condition is breached, it leads to a repudiation of the contract and damages. Repudiation means discharge the contract. I'm not doing it again. While warranties, when it is being breached, you cannot discharge the contract. You can only sue for damages. So it's important so that when, as a lawyer, somebody brings a particular case of breach of contract, you know how to couch your pleadings. You know how to couch your arguments to know if that particular contract or that particular term that was breached is one of condition, or whether that particular term that was breached was one of warranties. There are two instances and two scenarios I would want to give you, and I would give you time to marinate it and tell me whether one of them is condition and the other is warranties. One, there is a particular celebrity, an actress. They've called her to come and feature in a play. And this play is supposed to last for like 7 days, it's just 7 days program or 7 days theater program. And they've paid this particular lady to come and act. In fact, this particular lady, based on the contract, is supposed to come 6 days before the start of the event for rehearsals. Because even if you are a very good actress, you must have to rehearse the script that is being given to you in order for you to play it on stage. So she was expected to have come 6 days before. Then, after rehearsals for 6 days, they will now go into the program, and she will now do it for the next 7 days. Now, she did not come throughout for the rehearsal, and she did not even come up until the 4th day. And on that 4th day, of course, they had already replaced her because she was not forthcoming. Now, on the 4th day, she shows up. And she says she wants to do. And they told her, you will not do. And she now sues those producers or something. Now, that is one scenario. The other scenario is that this person is a singer. And he was expected, just like this actress that did not come. He was expected to come 6 days before the program. And he did not come 6 days, but he came 2 days before the program. He rehearsed, and he still has time to perform from the beginning. So which breach is a condition and which breach is a warranty? Now, if you say that the actress's breach is a breach of condition, then you are right. Because it was more serious than the other person that just attended 2 days rehearsal and started from the beginning of the program to perform. And so, this lady has not attended not only the rehearsal, but did not also attend 3 days into the performance. And so, the organizers of the event should have treated that, or should rightly treat it as repudiated, because we are not doing it again now, because you did not come as at the time you were supposed to come. And even if you did not come for the rehearsal, you did not even come for the main event. So that was a breach of condition. But, this person actually came, but he came 2 days before, even though our contract says come 6 days before the event. But he came 2 days before the event. You look at it as the event been affected by his not coming 6 days before, even though he came 2 days before. That is a warranty. I'll give you another example. A tailor, you agree, my graduation is on Sunday. I would need my graduation clothes by Saturday morning, so that at least when I test it and it does not fit well, you would have more time to amend it, so that on Sunday I would be okay with it. And the tailor brings it on the morning of Sunday. This is one tailor now with his customer. On the morning of Sunday. Remember, the agreement was bring it on a Saturday. Now, another tailor brings it on a Monday after the graduation. Which one has been breached for this tailor that brought it on the morning of Sunday, on the morning of the graduation? The contract for the two of them, these are two different people with two different tailors. The contract was the same. Bring it on the on Saturday, because our graduation is on Sunday. One brought his own on the morning of Sunday, not Saturday. On the morning of Sunday, he has breached a term of the contract. So which term did he breach? Is it conditional warranty? He brought it on the morning of Sunday that you could wear and go for the graduation. If that is the case, then that is warranty. However, the other one that did not bring it on the whole of Sunday
and the graduation passed, and he now brings it on Monday, has failed conditions. And of course, you can repudiate that contract. In fact, the contract is already repudiated, because what will I do with the clothes now? So, it is important you understand the nature of condition and warranties, so that when you see it in exam, you see the scenario that is being painted, you will now ask yourself, wait, is this particular thing a condition, or is this particular thing a warranty? Remember that their effects are different. While condition, we see to it that while breach of condition, we see to it that particular contract is repudiated. That is the remedy. And again, maybe damages. But the warranties will not see to it that the contract is repudiated. Because what are you repudiating? It is just a minor breach of something. Yeah? You can just maybe ask for damages, and that is it. So the difference, apart from in the nature, is also in the remedy that you get when any of them is breached. Now, we've seen condition and warranties, but there are some that you don't even know whether it is condition. You don't know whether it is warranty. Where do we place them? Innominate or intermediate term. Before we go into innominate and intermediate terms, let me also give you another example that also depicts conditions and warranties, and I will let you choose. Now, you've hired a photographer, and you say, this photographer, please come for my wedding, for your wedding, and you hired a photographer for your wedding, and you say, okay, this particular you have to come on the night of Friday, because the wedding is on Saturday, so that you do all this your bride what do they call that himself? Bridal shower. So you want the photographer to be there on Friday night, on Saturday morning, then on Sunday for Thanksgiving in church. Now, let us say the photographer did not come at night, but came for the actual wedding. What has been breached? Warranty or condition? Let us now say that the photographer came. Now, ordinarily, you want to make your event spectacular, and you want everybody to be on a specific kind of uniform. You want a particular color of the day, and you told the photographer that, see, I will pay you, wear a purple, that other vendors and other people that are going to be working in the wedding will wear purple. But the photographer came that night before the Saturday, and on Saturday did not wear purple, wore black. Which one is condition and which one is warranty? You will agree with me that him wearing purple, him wearing black instead of purple, is in warranty. Does it affect anything? You cannot repudiate the contract because he's not wearing purple. He's not wearing purple. But because he did not come from the very first time, probably you've got a replacement that came on that Friday evening. If he comes on Saturday, you can tell him, no, sorry, you did not come on Friday, please, I have repudiated the contract. That is a condition because he did not come on the Friday. So you should know that while warranty is just collateral to the contract, condition is essential to the contract. And the breach of condition is repudiation and or damages, while the breach of warranties is damages only without repudiation. Now, let us go into intermediate and innominate terms. Now, in condition and warranties, you already know the nature of condition. You already know the nature of warranties. You already know that in the nature, if it is conditions, this is what happens in case of breach. You already know in warranties, this is what happens in case of breach. But in innominate and intermediate terms, we don't know. In fact, it is kind of complex that we would have to know the effect of the breach before we can now talk about the remedy. So when a particular thing happens, when a breach occurs, and ordinarily from the nature of the breach, you cannot really say whether it is a condition or a warranty. But you are waiting for what is now the effect. What will now happen to the person that was injured? How is the largeness or how is the seriousness of the breach pertaining to the person that was injured? So you just see innominate and intermediate terms as doctor's report. You don't know what to treat, isn't it? Until the doctor's report come out. I'll give you an example. If I tell you, now, you come to my shop, I sell phones, and you tell me that, see, I'm a content creator. I need a phone that the camera is very nice. Yeah, I need a phone that is very nice. Like, I'm a content creator. What I only need the phone for is just to make videos. And sir, I have iPhones, I have Samsungs, I have, without prejudice to other phones that makes, good cameras, but I just believe the iPhone and Samsungs are nice. So, I have iPhones, I have Samsung. Choose. Now, you now choose one, and you see the camera is very nice. The contract is that you want a phone that is a very good camera phone. Now, you now reach your house, and you now see that the phone is problematic as regards calling. Maybe it doesn't get network, or the Bluetooth spoiled. Now, because I promised you a good phone, let us probably leave. Okay, I promised you a good phone that will serve you, and you now find out that the phone has problems. The question that will be asked is whether that breach deprived you substantially of the enjoyment of that particular contract. Now, if that breach deprives you of that enjoyment, then it will be treated as repudiated. However, if it does not, it will be damages. Innominate or intermediate terms. You see that there are, in terms of remedy, they brought from here and brought from here. But on the test, what is the test? The substantial effect test. What is did it deprive you of the substantial benefit? Substantial benefit test. Did it deprive you of the substantial benefit that you would have enjoyed in that particular district? Now, if you now look at this analogy I gave of phone, what you want based on the contract is a good camera phone. So, in essence, did it actually that the call is not working? The call network signal, it doesn't receive network, and the Bluetooth is not working. Does it deprive you substantially of the benefit of good camera? If the answer is no, then it is only damages that I will pay you. If the answer is yes, that I am supposed to, okay, let us say it is now the camera that is at fault, then the remedy would be repudiation. You see what I'm saying? So, as innominate and intermediate term, just know that by the nature of condition and warranties, you already know that this is a condition and a warranty, and you know what happens when any of them is breached. But innominate and intermediate terms, you only wait for the effect of the breach. When you breach an innominate and intermediate terms, what happens? That is when you now know the remedy to ascribe. Do you understand? So you see, it's Deep Lock LJ that brought out these innominate and intermediate terms. So you look at, did this thing actually deprive you of the substantial benefit? If it does, then it's repudiation. If it does not, then it's damages. There is a particular case that a shipping company, I think it's the one that is a Hong Kong fair shipping company against some people. Somebody hired a ship, and the shipping company assured them that the ship is of good condition and very nice. And so they carried the ship. They are supposed to have done, been with the ship. They hired the ship for, I think, about 3 years or so, but it's just a long period of time. But something happened. It now was discovered that the ship was bad, the engine was bad, and the people in the ship were inexperienced. So, because they had already started using the ship, they needed to repair it. Now, the repair would have taken about 15 weeks. So, they now said the fact that the contract is repudiated. The court said no. How many years is it remaining for you to use this contract? Is it not just 15 weeks that you would have to repair it? So you cannot really treat it because it has not deprive you of the substantial benefit of that particular ship. It would have been different if you needed the ship for like 3 weeks, and this particular repair is supposed to last for 15 weeks, which is more than the 3 weeks. Then you can say that the substantial benefit has been deprived of you. But you still have the ship for like more 3 or 4 years. 15 weeks will not do any harm to you. But then damages must be paid. So you did not pass the substantial benefit test for you to be repudiated. So court ordered damages. Do you understand? So that is innominate and intermediate terms. Now, fundamental terms is just very simple. That's the one that goes to the root of everything. I want a car. I want a Camry. You now brought me a Corolla. You have breached the fundamental term. The fundamental term is the root, is the basis upon which the contract is formed. So if you do anything outside what the contract says, that is a breach of fundamental term, which of course leads to repudiation. So, until I meet you next time, I remain the professor. Kawade.